Hello everyone, thank you for joining DataCon LA 2020 and welcome to the Emerging Tech Track. Soon we will be listening to Big Data and the Law, what every data enthusiast should know, with Hana. I'm Lawrence Gilio, your host, and our co-host is Murali. We will be moderating the chat and Q&A, so please get those questions in for you during the session. Today we have our guest Hana, and she will be talking about big data and the law and what every data enthusiast should know. She is an MIT graduate, trained attorney in Melbourne's Intellectual Property and Technology Group, and has spoken at national conferences and the Practicing Law Institute. She focuses on patent and trade secret litigation and licensing issues for innovative companies. In her pre-law life, she conducted postdoctoral research at a leading biotech company and understands the importance of protecting valuable intellectual property assets in science and technology. And now I'm going to hand it over to you, Hana, for your presentation.
Thank you, Lawrence. Hi, my name is Hana. It's very nice to meet everybody over this this forum or this setting that's a bit different from how we usually do conferences. But big thanks to Subhash and Lawrence and Murali and others who have put it together. And from what I've seen so far, it seems like it's been working really well, and they've done a great job trying to foster a sense of community when it can be really hard over a virtual setting. So thanks to you guys, and thank you for attending. So as Lawrence mentioned, the session here is generally going to center on the role of big data and its intersection with the legal field. And having worked or touched on both of them, I had some thoughts that I wanted to share. And of course, we have a somewhat limited time here today. So what I was hoping this would do is for us to get started. This would more be a beginning of a conversation, and it's not meant to be like an overarching, complete and full primer on the issue. But I think it's interesting for a lot of reasons that I'll go into. And having looked at some of the backgrounds of folks attending, it seems like there's not a whole lot of knowledge in this area, which isn't surprising because part of the reason I wanted to do this is because there isn't as much overlap as you would think. And I think there's a large opportunity being missed there. So that's sort of what I wanted to situate ourselves into. And I think it also helps to kind of look at where we are headed, right? We want to discuss how and in what ways big data has shaped the legal field and what, if any, effect it has had so far, what has worked well, what hasn't, and why it's interesting. And I really wanted to focus on the reasons why the legal field has actually been quite slow in adopting a lot of the ideas behind big data and using big data to its advantage. And as I said, a lot of people find this somewhat surprising given just how much emphasis there is in the legal field on analytics and using a full, scope of information. And that then ties into our next sort of topic or issues that I wanted to discuss, which is what developments have there been, especially in the recent couple of years, and what opportunities remain. And I think I'm using the legal field here because that's the one I know well, that I work in, and I think it's sort of underserved in this regard, but I think it also can serve as a helpful platform for data scientists to think about in what ways those who are experienced in big data can potentially help out and make a difference in terms of how things are done. And Lawrence has discussed and done a very kind introduction already, so I won't go into too much detail about my own background, but I just wanted to note that the reason I find this personally fascinating, and not just professionally, but on a personal level as well, is that I've worked in engineering before entering the legal field. where I myself, my own research relied heavily on large volumes of data and how it shapes, in that situation, the biotech field. And that was my focus before, I guess, crossing over to the dark side, as some might say, and becoming an attorney. So now I work mostly in patents and trade secrets. And most of my clients tend to be either semiconductors, information technology, biotech, and pharma. And for that reason, a lot of the examples that I'll be using will talk about patent and trade secret cases, although I'm trying to make it a bit more general in the legal field as well. But I think looking at it from an IP or intellectual property perspective lends itself to a lot of really interesting questions as well. So as I touched on earlier, law and data has had a somewhat complicated relationship leading up to today. And surprisingly, even though both have a lot of emphasis on analytics and having that inform decision-making, surprisingly, in the legal field, there hasn't been a whole lot of openness or adoption of a big data-based approach. And there's several reasons behind it. And some of these are sort of research that has been done into why that is, and also others are based on my and my colleagues' experience. But one reason is that law tends to have a very heavily precedent-based approach. And what that means is, even though sometimes it might seem like it from news reports or popular reporting, law is an area where it very much is focused on and is based on things that are being changed at an incremental level, meaning it's a step-by-step change. It's usually not a field where changes are made in a sweeping or an overturned kind of way. In order for a legal opinion to be issued, looking at it sort of at a global perspective, right? Very generalized. One company or one party sues another party. And the way you advance your argument in the legal field, a lot of it is what we call analogizing, which means that these are the facts and this is the law that applies here, right? And a lot of the fight ensues about how the facts in these earlier cases, what are called precedent cases, apply to this situation. So as plaintiff, you're going to argue, well, I deserve the remedy that I'm arguing for because our facts are similar to these facts in this other case. And you'd cite a number of different cases that have come before you. And even better if it's in your own court or the same judge. And then the other side, the defendant, is going to be doing the same. You're going to argue, no, our facts are similar to these other sets of cases, right, which came out the other way, because a lot of it involves interpreting the law and applying the facts to the law to make your argument. And in addition to saying why your fact pattern is similar to the fact pattern in previous cases in precedent, you're also going to argue, well, our situation is different, and this is why. And in that way, you're trying to distinguish other cases that the other side is relying upon. So all of which to say is that the legal field historically, when it comes to legal opinion issuing, the judge is going to cite a bunch of other cases that have come before him or her, and doing these analogizing type analysis where they would say, this is similar in this way, and that's why I'm going to rule similar to this other case that have gone before me, right? It's going to be very rare, and actually the judge's power can be quite limited in terms of coming up with a brand new way of doing it, or innovation or things like that. Just can be a little bit ill-fitting in terms of how law is evolved and how legal opinions get decided. So there's a lot of emphasis on sort of what happened before, how have other cases been decided, and how should that be reflected in this next step. And because of that, there's been sort of slow movement, but nonetheless, there have been quite a big range of changes in terms of the legal field embracing big data. And that has a number of different reasons, a number of different scopes in terms of how that has happened. One example of that, or one reason behind that, is just the sheer amount of volume, period, right? Not just in the legal field, but in general. There have been studies showing that the changes and the increase in the volumes and types of information hasn't only been just large or a factor of X. It's been factors of thousands, if not hundreds of thousands. It's just a very fast pace that a lot of people and companies sometimes find hard to follow, right? And tied to that is also a process called discovery, which in a legal situation, as I mentioned in the example before, where company A sues company B, there's a lengthy discovery period, or depending on the case, sometimes it's not even that lengthy, where basically you assert certain requests, whether it's for information or for documents. And in response to that, while there's some negotiation as to scope of what that is, you will be obligated under law to turn over that information. And of course, that scope of information has really increased in volume too. So in conducting discovery and what we now call e-discovery or electronic discovery, there's a lot of emphasis on a party's skill and ability to deal with really large volumes of data. So before, it may have been just, conducting some searches on hard copy paper or notes, and now you're going to have very sophisticated search functions involved, how to tweak those search terms, in what ways the searches should be run, and on what targets. These are all emerging questions, and actually even more than emerging, they've become much more developed than they have been before. And a lot of big data concepts are now being applied there as well, mainly because the volume of those target documents is so much larger than it was before. And then finally, while I've used some examples in litigation context, including discovery, there's also a lot of corporate analytics, right? When a company decides to either acquire another company or partner with them, it used to be that before there was sort of a set limit or set boundaries of information. And now that there's so much more analytics and evolved ways of analyzing information about the company, there's a lot of input opportunities for big data to play a role there, where how do you parse through this huge volumes of data that's available in a company and identify the ones that are really relevant. In other words, if you're trying to acquire the patent portfolio of another company, then it may or may not really matter for you just how much work they've done in, in an insurance context, for example, right? And a lot of times they are tied together though. So the ability to take a large volume of data related to a particular company or corporation and determining how to obtain the relevant information that's helpful to your decision-making in particular has been a huge area of interest in the corporate context, and one that unfortunately there just hasn't really been a whole lot of development or a whole lot of advancement in terms of how we do things. And just to go into the discovery part of it a little bit more, as I mentioned, in the past, when a lot of the documents, and especially situations where a lot of it may be old documents, it used to be that a lot of it involved scanning documents, running search terms on it, and maybe even some human review of actually looking at physical documents and boxes of documents. And now that that's almost all moved to electronic versions, there is a lot of emphasis on how do we really process all of this huge volumes of data. And similar to what I just mentioned about corporate analytics, there's a lot of questions about how do we look at these volumes of information from each company and identify what's actually interesting. And what I've seen a lot this in the context of is, for example, pharmaceutical companies where there are a lot of laboratory notebooks and they've done their own research and their own development. And what makes it tough is a lot of these things, right? The types of technologies that get to litigation, not all, but most of them tend to be pretty complex technologies where you have to really understand years, if not decades, of development. And again, using the patent litigation as an example, what somebody then would have to do is show, well, look, we own this technology, we own this patent, and this is how we've developed it. And you have to be able to back it up with a lot of documents, right? And supporting information. And the ability to arrive at those few, fewer than 5, 10, 15 documents out of literally hundreds and thousands of documents, that can be extremely difficult. And there are some specialized firms popping up who are doing those specialized e-discovery type work, but it's still an area where a lot of it really still depends on how sophisticated and how carefully crafted are your search terms and how effective are they in identifying just the types of information that you would need in order to make your point when it comes to discovery and turning over the documents to the other side and also identifying what's helpful to you. And that goes both ways because discovery, as many of us lawyers like to say, is a two-way street where you're producing a lot of documents to the other side, but you also obtain a lot from your opponent as well. So in order for you to, as somebody who's sued in a patent infringement suit, for example, you'll need to be able to argue that you're not infringing that patent because, for example, we developed this technology on our own rather than copying this patent, and this is how they're different. And a lot of those differences that you will have to point to are very nuanced, and you'll have to be fairly careful in terms of what types of details you can rely on to make that argument. And for that reason, again, this is an area where there is an increasingly large amount of data involved and pretty sophisticated targeting type approaches that there are some developments, but it's still evolving and there's a lot of sort of room for additional input there. And what I've mentioned so far has looked at the types of information and documents that are possessed by companies, right? And of course, the volumes there are huge. But what's more and more prevalent and also interesting on a different level is litigation that involve individuals. And I'm not just talking about, what you would probably normally pop into your heads about individual litigation, whether it's criminal or white collar crime type situations, but also in the IP context. Compared to patent litigation, trade secret litigation has increased significantly over the past several years, and there now is a federal law as of just a few years ago. So there's been a huge increase in the types of litigation in the trade secret context that's asserted. And I mention that because trade secret cases does involve a lot of individuals. I think some of you may be familiar, for example, in the Uber case that involves trade secret issues, or Google has also been involved in several of those litigations as well. And the reasons that those types of cases involve individuals rather than just the corporations is because in trade secret context, a lot of the defendants, right, or the alleged defendants tend to be individuals. Over 80% of all trade secret cases involve either a former employee or a partner. So that sometimes people find surprising. Contrary to what's usually shown in the media, it's not some corporate spy or some unknown person sneaking into the night, in the middle of the night, into your corporate facilities. It's someone you know and it's someone you trusted, which in a way makes sense, right? I mean, trade secrets by definition is something that's only known to your company, and it's something that's carefully guarded because it derives value from being unknown. And I guess a popular example is the formula for Coke, but this can also involve a whole lot of other types of information that a company seeks to keep secret. And by virtue of that nature of that information, what happens is that those individuals who have access to that carefully guarded information is going to be someone who's either an employee, right, or a partner who has signed an NDA or a non-disclosure agreement, who is then under an obligation to not disclose that information, but does anyway, and then that's where trade secret litigation ensues. Anyway, long-winded way of saying there's more emphasis and more interest in parsing individual data, and that's because now, with individuals, there's a whole slew of other types of data that enters the picture in litigation. That can include text messages and information or messages exchanged through chat functions, and even those that purportedly are, impermanent or not meant to be saved. There are ways to uncover what has been exchanged in those information exchanging forums like chats. And internet search history is another one, as well as social media, where if an individual is implicated in trade secret theft or theft generally even, now there's a lot of other data that is becoming involved because of it that can be tied to specific individuals. And just as a trade secret example, there have been cases where we've looked at, just the word search history, right? You could imagine just how many things and search strings and words there are for an individual over the course of usually years, which is the time period that you're looking at. And we have uncovered information that is relevant to the case. And another important note here is that what big data allows litigation individuals involved in litigation to do is to place things in context. So for example, one search history or one search string about what happens if I steal trade secret, right? What's the implications? Someone searching for that one time or maybe even 2-3 times may not mean much, but put in the general context of that person has searched for this never in their 20-year history of the firm or whatever, but they have searched for it extensively in the period of 24 hours before they went and did whatever the company is accusing them of doing. That is information that's helpful and it's relevant, but it may get lost if you're only zeroing in on a shorter time period. So another reason why this is becoming increasingly important is that big data now gives you the ability to put things into perspective and to put things into context where individually it may not have meant much. And that's sort of related to the developments in forensics generally. And again, there's the criminal case forensics, of course, but my own experience and the developing research has been also on the electronic forensics front. So for example, in the trade secret situation, a lot of searches or deleted files or things that people can do to try to cover their tracks, right, can actually be uncovered with increasingly complex forensic tools now. And I mean, it's really quite impressive in terms of what can be done. What has this individual done to try to not only delete, but try to erase all traces of some given file, right? Computers that are being wiped or phones or tablets that are wiped wiped with pretty sophisticated software too. So there's just this sort of dueling technology in terms of how effective can you be to erase information and how much advancement there has been in terms of trying to uncover it. I mean, we've had cases where we were able to not only recover files, but also recover different versions of them that the individual had thought they had deleted and they had wiped out that computer at least twice, if not more. So again, putting it into the context of what other files did that individual have and the ability to quickly process a lot of that information has been really a key in this field and in litigants being able to make their arguments and trying to show why their arguments should be supported as to whether or not this person has performed trade secret theft. Another area, sort of shifting gears a little bit away from forensics and data recovery, is litigation analytics. So this is more in the viewpoint of a litigation attorney, right? And what we do a lot of times, and what we have done for many, many years before this field of analytics has really evolved, is we would, as I mentioned before, law is heavily centered and heavily based on precedent-based approach. So we would look at previous cases, especially those by this particular judge or this particular jurisdiction in this court, and then we would go to other courts and other judges if we're not able to find something that's helpful for our argument, and say and be able to argue, well, we should apply this law and interpret it in this way because all of these cases that I'm going to cite here have reached a similar conclusion. And then you would also take the second step of the cases that my opponent is citing, they are different, and you would now try to distinguish them by saying, well, they either came out wrong or our situation is different because of these factual differences. And that's still the case, and that's still what we do, but this is one area where big data and data scientists have really made a lot of headway, which is analyzing these previous cases, but in a way that takes some of the more data-driven approaches. So rather than sort of looking at a few cases that you're aware of or doing your research about using some set of keywords, you would be able to, and you are in some ways beginning to able to access all the motions, right, that have been filed before this judge and all the motions that made the exact same argument that you did. And that, of course, given the hundreds of years of litigation in this country. And as you know, being a very litigious country, we have a lot of them. And humanly, it's not really possible to parse through all of it on your own, or even with sophisticated computer-based methods. But given the changes in the analytics, and as I mentioned, this is still an evolving field, although one where big data approaches have made quite a big of a difference, you can now search for, okay, what types of motions have been filed that have been successful? What cases did they cite? How did this judge historically come out on this front? And that's an analysis of judges who have been on the bench for decades and analyzing how they have ruled, and taking that one step further, taking a predictive approach. Okay, based on all this data, right, how likely is it that I'm going to get the verdict that I need or that I want? And another issue that's important to a lot of clients is, because litigation is so expensive, I want to know, am I going to be in trial for 2 years, for 3 years? I mean, a lot of the cases that we handle that are large can go on for many, many years, right? Even after the patents that issue have expired, et cetera, because litigation can be a very lengthy process, and for a number of reasons can be very complex as well. So clients want to know, corporations want to know upfront, how long is this going to last? How quickly will this judge set the trial date, or any dates before then when we may come out and have a decision on our hands? And those types of questions can now be answered with fair accuracy, although that's on the way of being improved right now, how long it's going to take for a particular judge or on a particular issue. And that, of course, is very powerful. And as I mentioned, there's still a lot of room in terms of improvement in that aspect. Taking a more zoomed in approach, I've talked about the case overall and the judge's ruling overall, but looking at sort of the day-to-day of an attorney, these days when we're writing our briefs and advancing our legal arguments, all of that is based on, in large part, prior cases and other arguments that have been successful. And I've touched on the concept of citing 2 cases that you want to rely on, right? And another way that data scientists have now improved this, but this is one area where it's sort of still nascent and there's a lot of room for additional improvements, is analyzing all of those volumes of legal orders and legal briefs that have come before you and identifying other case sites that might be helpful. So there may be cases that the particular brief or the particular attorney has overlooked, and the database approach can inform you, well, in your situation, in past cases and past briefs, an attorney making similar arguments has cited to these types of arguments or these types of cases and made these kinds of arguments. And that kind of mining for your data that can be helpful for your argument in terms of the cases that have come before your particular case can also be incredibly helpful. And still not quite where it really should be. I think there are a lot of glitches and false positives as well as false negatives. So that's an area that I hope will sort of continue to be involved in being improved by data science as well. I've mentioned a lot of litigation contexts, partly because that's where a lot of the big data driven changes have been happening, and also partly because that's my own area of expertise. I do mainly litigation. But big data and concepts in big data have also been used in litigation, in non-litigation contexts as well. And that includes, for example, before you go into litigation, how much information do you have about a particular attorney, particular firms, or this particular opponent? And a lot of that used to be sort of just industry reports and your own experience with that particular firm or with that particular competitor. But nowadays, there has been a lot more analytics on this front as well. You can gain a lot of information about a particular company with whom you may be involved in litigation. And that goes the other way too. Before you sue a different company, right? You think they're infringing your patents, or you think that they're using your trade secrets, but is this really going to be worthwhile for you in terms of bringing this very expensive lawsuit? And when I say expensive also, it's not just monetary. those of you who have been involved in litigation will understand this and appreciate it, which is that it pulls away your employees from your day-to-day job, right? So if someone's involved in R&D, if they have to be in a deposition or if they have to go testify at a hearing, that is usually weeks of preparation. And also being involved in litigation means you have to turn over a lot of the information to the other side, which I've covered a bit in discussing discovery. So that means it has to be someone knowledgeable in that field to be able to pick out information that they think is going to be helpful and relevant, and they will then need to turn it over, right? So a lot of that involves expenses of the company, and that's why litigation gets to be so expensive, not just the dollar amounts, but also the time invested and the talent invested by some of your most valuable employees. All of which to say is that the more knowledge you have about how successful or how likely it's going to be that you're going to come out successful is depending a lot on data that's being provided about the company and the types of lawsuit that you're considering to file. And just as a couple of other litigation related examples is if you're trying to acquire information, that you're trying to acquire another company or considering licensing some of their intellectual property. Just as intellectual property as an example, we now have literally tens of millions of patents out there, right? I think we crossed that mark quite a while back now. And what that means is in order to analyze the patents, you may have to kind of go beyond just the patents themselves, but all of the patents of their competitors where they may be able to argue that you're infringing the patent so that you can argue that this patent portfolio is valuable or not valuable. And you can make that a simplistic analysis if you want to, but oftentimes it's a very belabored and complicated process because you have to parse the patent claims, you have to put that in the context of other patents that are out there in the field, what technology is being used, and all of that, again, is an area and an inquiry that's being informed heavily by patents and by patent-specific analytics that are heavily based on big data concepts as well. As some of the evolvements or examples of evolvement that have occurred in the big data informed decision-making context is some of the more recent case law regarding venue. And by venue, I mean a company can decide where to bring their lawsuit. And that's usually the plaintiff can decide, and there are some limitations as to where they want to do it. And typically, they would want to do it in a venue that's helpful for them, right? It could be a number of reasons. One could be, it could be close to that company, so just reduces the time for travel, although these days in COVID times, a lot of it is virtual. But before all that, it was important. Do you want to file in Texas or out on the East Coast if you're really a West Coast litigant, you know, knowing that you'd have to go there extremely frequently and fly your employees out there and be disruptive to their day-to-day jobs. And from a defendant perspective, even though the plaintiff decides the venue, you can request to have that transferred for similar reasons. You know, you want it to be closer to your home base, or a lot of times actually, if it's going to be a jury trial, there are differences to consider, right? Is this jury pool going to be more, have a propensity for agreeing with my side or my opponent's side? And that can be extremely important and play a huge role in terms of where the decision is going to come out. So a lot of that decision making is going to be based, again, on analytics-based approaches and based on big data, where you're looking at a potential venue and you can analyze during the last, decades, if not longer, how have jury pools ruled on this issue, or if it's about a particular judge, if it's going to be a judge-based decision, how has this judge ruled in similar situations? And that can inform not only litigation, but also settlement discussions in terms of how do we want to approach this with our opponent. And in the context of patents and trade secrets, I've kind of mentioned examples from that. I think in the interest of time, I'm going to not really go into too much depth about how these types of intellectual property have shaped litigation, but I'll try to weave it into discussions in the other slides. So for example, in the patent litigation context, I've mentioned the limitations on venue shopping. There was a case called TC Heartland from the Supreme Court fairly recently that have really limited in terms of where a plaintiff could perform what we call venue shopping, you know, trying to file a case where it's going to be more attractive to them. And as one example of this, the Eastern District of Texas used to be an incredibly popular venue because the judge and jury pool tended to be very patent owner friendly. So a lot of the patent owners had decided to file there. But now after TC Heartland, that's extremely, well, not extremely, but it's more difficult than before. So for that reason, other venues have seen a pretty large increase in patent litigation filings. And that includes, for example, the District of Delaware, where a lot of the companies are incorporated and plaintiffs can say they have a tie to that forum for that reason. Another one is actually here, Southern District of California, as well as Northern District. And Northern District has always been popular because a lot of the companies, especially tech-based, are based there, and the jury pool there have a very sort of specific viewpoint in terms of how they rule as well. But basically, I mean, the point here being is that now that there's some limits on where you can file and where you can transfer to, it's even more important to really understand how a particular venue or how a particular jurisdiction is going to come out for you. And as another example is the non-practicing entity example, which I have a picture of a troll here because some not so charitably call them patent trolls, which is referring to companies that have amassed a large volume of patents and are asserting them against companies. And they're not practicing in the sense that they don't make or manufacture products, they only have patents. And that's, of course, kind of a headache to companies who are being sued by them, you know. And usually Samsung, Apple are some of the biggest targets where they do have products. And because they have so many, they can be targets of various NPEs asserting that they have patent claims against them. And the reason that's important here is because they tend to have these huge volumes and large portfolios that they're trying to assert. So companies have increasingly seen a need for understanding fully what all of those portfolios encompass, and also how that can be distinguished or even invalidated by arguing that, you know, they shouldn't have been issued as patents in the first place because there are so many other patents or other documents out there. There's also been a Supreme Court Alice case, which puts some limitations in terms of the types of patents that can be granted, which again informs, is another reason why this has been pretty tricky in terms of companies trying to assert patent rights based on limited information, and another reason why big data has been increasingly important. So I think we're coming up against the times. I'll just mention one other thing, which is trade secret cases. And this is a summary of examples of information that have been held in courts as examples of trade secrets. So as you can see here, a lot of them are based on big data itself. And as I mentioned earlier, trade secret cases have really seen a huge uptick. And for that reason, it's really important, or increasingly important, for those in the legal field to understand how to analyze big data, what big data even is, and how that can be explained in a trade secret way. You know, you have to be able to explain why this big set of data-driven information is indeed a trade secret. So with that, I'll just thank everyone for your attention. I'm happy to answer questions. And going back to where I started, I'm hoping that this was really a conversation starter. I believe my information should be on the app or on the website. I'm always happy to talk about it. I think it's big data in the legal field is a fascinating area that has seen some development, but as a personal data enthusiast and a lawyer, I really feel that this is an area where it's ripe for opportunities, and I really hope that more of you professionals involved in data science sort of give it a look and consider some of the other advancements that can be brought to that. With that, thanks very much, and again, happy to take any questions.
Thanks, Hana, for your excellent presentation. Very informative. Do we have any questions there, Morali?
We don't, Lawrence. We don't, Hana. We have not seen the questions, and we're up against time. So I would encourage the attendees, in case they come across a question or a concept they were unclear, when they, remember something or review the video, they can always get hold of you through the Woo app. Anything else you want to say, Lawrence?
Yes, thanks again, Hana, and thanks for all the attendees. Please provide your comment or any feedback to us or the organisers on the community board. We'll start a discussion there to connect with others in the DataCon LA 2020 community. Thanks for joining today's presentation, and I hope you have gained any insights from the session. Have a wonderful day, and thank you for being part of this year's DataCon LA 2020. Bye for now.
Thank you. Bye-bye.
Thank you.